My husband laughed when I walked into that courtroom alone. He leaned over to his attorney, whispered something, and they both smiled. His mistress, sitting in the gallery 2 rows back, didn't even try to hide it. She covered her mouth with her fingers. But I could see her shoulders shaking. Everyone on his side of the room seemed to share a private joke, and I was the punchline. I was 31 years old, standing in a federal courthouse in Charlotte, North Carolina, wearing the only blazer I still owned, carrying a manila folder I had organized and reorganized 17 times the night before. No attorney beside me. No paralegal behind me. Just me, that folder, and 6 years of a marriage I had given everything to. My husband, I'll call him my husband because that's what he still legally was, had 3 attorneys. 3. The lead one, a silver-haired man named Gerald Weston, had a reputation in Charlotte that preceded him into every room. He had a corner office downtown, a Wikipedia page, and a dismissive smile he wore the way other men wore cologne. Constant. Suffocating. Gerald Weston looked at me the way you look at something small that has wandered somewhere it doesn't belong. I set my folder on the table and sat down. I need to tell you how I got here because the courtroom is not the beginning. The beginning was a Tuesday morning 18 months earlier, when I came home from my early shift at the hospital. I was a cardiovascular research coordinator, had been for 4 years, and found my husband sitting at the kitchen table with a document in front of him and an expression I had never seen on his face before. Not guilt. Not fear. Something colder than either. "I need you to sign this," he said. I set down my bag. "Good morning to you too. What is it?" "Separation agreement. I've already had it drawn up. It's fair." I stood very still for a moment. The coffee maker beeped. Outside, a garbage truck rumbled past. The world kept moving in its ordinary way while mine tilted sharply beneath my feet. "We're not separated," I said. "We will be. I think we both know this hasn't been working." He slid the document across the table. I had Gerald look it over. "You get the car, the furniture, and 3 months of support payments. The house stays with me. My business assets are separate property. I had them structured that way before we married, so there's nothing to argue about there." I looked at the document. I looked at my husband. I had loved this man. I had worked double shifts while he launched his commercial real estate firm. I had skipped conferences, postponed my own graduate program, rearranged my entire life around the architecture of his ambitions. "I'm not signing this," I said. His expression didn't change. "You don't have a choice, sweetheart. You can't afford to fight it." I picked up my bag. I walked to our bedroom. I sat on the edge of the bed and stared at the wall for a long time. He was right that I didn't have money. What he didn't know, what he had never bothered to learn, because he had never truly paid attention to what I did, was what I did have. Let me tell you about my work, because it matters. A cardiovascular research coordinator at a teaching hospital does not simply schedule appointments and file paperwork. I managed multi-site clinical trials. I worked alongside biostatisticians, FDA compliance officers, and legal teams on a daily basis. I had handled more documentation, more regulatory filing, more procedural law than most people encounter in a lifetime. I understood evidence chains. I understood how institutions investigated fraud. I understood, better than my husband ever imagined, how money moved when someone was trying to hide it. And for the past 2 years, without fully understanding why, I had been watching his money move in ways that troubled me. It started small. A transferred account I wasn't told about, a property listed under an LLC name I didn't recognize, an offhand comment from his business partner's wife at a dinner party, something about a second set of books that she laughed off immediately, the way people laugh off things they wish they hadn't said. I hadn't confronted him. I had documented. I have a methodical mind. It's what makes me good at my job. When something doesn't add up in a clinical trial, you don't accuse anyone. You document, you verify, and you follow the data until it tells you what actually happened. I had been following data for 2 years. By the time he slid that separation agreement across the kitchen table, I had 347 pages of documentation in a secure cloud folder that I had been building quietly, carefully, the way you build anything that needs to last. I didn't tell him that. I just picked up my bag and started making calls. The first attorney I contacted told me my case was complicated. The second told me retainer fees started at $12,000. The third one actually laughed, not unkindly but still. I didn't have $12,000. My husband had made sure of that. 2 weeks after our conversation at the kitchen table, I checked our joint account and found a balance of $412. He had moved everything else. Quietly, legally, he would argue. The morning I discovered it, I sat in my car in the hospital parking garage and allowed myself exactly 8 minutes to feel the full weight of what was happening. Then I drove to the library. In North Carolina, you have the right to represent yourself in civil proceedings. It is called proceeding pro se. It is not easy. It is not recommended. But it is a right, and rights do not require money. I spent the next 14 months learning family law the same way I had learned clinical trial regulations, methodically, obsessively, one document at a time. I attended free legal aid clinics. I filed every motion myself. I made procedural errors and corrected them. I read case law until 2 in the morning on nights before my early shifts. My colleagues at the hospital thought I was studying for a certification exam. In a sense, I was. What I was really doing was building a case that Gerald Weston, with all his silver hair and his Wikipedia page, was not going to see coming. My husband was not merely hiding assets in the divorce. That was almost the minor part. What I had documented, carefully, over 2 years, with dates and account numbers and transaction records pulled from sources he didn't know I could access, was a pattern of wire fraud involving 3 of his commercial real estate deals. Investors had been told their money was going into properties. The money had gone somewhere else first, briefly, before returning. The kind of briefly that leaves fingerprints if you know where to look. I knew where to look because a forensic accountant at my hospital had once walked me through exactly this pattern during a research compliance training session. She'd used it as a hypothetical. I had taken notes. 8 months before the court date, I had sent my documentation, anonymously, through proper channels, to the FBI's Financial Crimes Division and the North Carolina Securities Division. I did not tell my attorney. I did not have an attorney. I did not tell anyone. I simply continued preparing my divorce case, filing my motions, showing up to every procedural hearing in my one good blazer, while Gerald Weston looked through me like I was glass. The morning of the final hearing, I was in the courthouse at 7:45. The hearing didn't start until 9. I sat in the hallway on a wooden bench and went through my folder one more time. Every tab, every exhibit marker, every line of testimony I had prepared. A young clerk passed by, slowed, looked at my folder and said, "You're pro se?" "Yes," I said. She nodded slowly, the way people nod when they want to say something encouraging but can't find the right words. "Good luck," she said finally. "Thank you," I said. "I don't think I'll need it." She gave me a slightly uncertain look and continued down the hallway. At 8:50, my husband arrived with Gerald Weston and 2 associate attorneys. They were talking and laughing about something, the easy laughter of people who have never once doubted the outcome of their day. My husband saw me on the bench and said nothing. Gerald Weston glanced at me and then away, a glance so brief it was almost its own kind of insult. They walked past me into the courtroom. I waited 2 more minutes. Then I followed. The judge assigned to our case was the Honorable Renata Okafor. She had been on the bench in Mecklenburg County for 11 years. She was known. I had researched her. For an intolerance of procedural gamesmanship and a precise, unhurried intelligence that had made more than one overconfident attorney regret their assumptions. She entered the courtroom, took her seat, and reviewed something on her bench for a moment before looking up. Her gaze moved to Gerald Weston's table. 3 attorneys, immaculate suits, leather folders. Then it moved to my table. 1 woman. 1 manila folder. A glass of water I had poured from the hallway fountain. Her expression gave nothing away. "We're here today in the matter of the dissolution of marriage," she said. "I've reviewed the pretrial motions. Before we proceed, I want to note for the record that the respondent is appearing pro se." She looked at me directly. "You understand your rights in this proceeding?" "Yes, Your Honor," I said. "I do." "Very well. Mr. Weston, You may proceed with your opening. Gerald Weston stood with the fluid confidence of a man who had done this 1,000 times. He spoke for 11 minutes. He described my husband as a self-made businessman, a man who had built his firm from nothing, whose assets were entirely and clearly separate property predating the marriage. He described me as a woman who had made modest contributions to a household and was now seeking an outsized share of wealth she had no legal claim to. He used the phrase unfortunate but straightforward 3 times. He sat down. Judge Okafor looked at me. I stood up. Your Honor, I said, I'd like to begin by entering into evidence Exhibits A through S. I heard Gerald Weston shift in his seat. I had 19 exhibits. They were organized, tabbed, pre-marked, and I had already submitted courtesy copies to the court clerk and opposing counsel per proper procedure, a procedure I had verified 4 times because I could not afford a single technical error. Exhibit A was a property deed. Exhibit B was an LLC registration. Exhibit C was a wire transfer record. By Exhibit F, Gerald Weston had leaned over and was whispering to my husband, with an urgency that was very different from the comfortable murmuring of that morning. By Exhibit K, a set of financial records showing the movement of marital funds through a series of accounts that my husband had sworn under deposition did not exist. The courtroom was very quiet. Judge Okafor had not looked up from the documents in several minutes. She was reading. Slowly, carefully. Gerald Weston stood. Your Honor, I'd like to request a brief recess to review. Sit down, Mr. Weston, Judge Okafor said without looking up. He sat down. I want to describe what happened next as a moment of drama, because it felt like one from the inside. But the truth is, what happened next was quiet. Procedural. It felt almost bureaucratic, and somehow that made it worse for my husband than any shouting would have. Judge Okafor set down Exhibit K. She looked at Gerald Weston. Counsel, she said. Are you aware of the federal investigation currently open into your client's business dealings? The silence that followed was the loudest thing I have ever heard. Gerald Weston's expression did not collapse. He was too practiced for that. But something moved behind his eyes. A rapid, private recalculation. He said carefully, Your Honor, I'm not certain what. Because I received notification from the U.S. Attorney's Office this morning, Judge Okafor said, that this proceeding may involve assets currently under federal review. She set down her pen. She looked at my husband. I'm going to ask you directly, under oath, whether you have been contacted by federal investigators regarding the Harlow Street and Meridian Point transactions. My husband looked at Gerald Weston. Gerald Weston looked at the table. My husband looked at me, for the first time since we had walked in that morning. Really looked at me. And I watched his face do something I had never seen it do in 6 years of marriage. It went pale. Not dramatically. Not theatrically. Just a slow, quiet draining of color, like a tide going out. I need to consult with my attorney, he said. You may do that during the recess I'm about to call, Judge Okafor said. 15 minutes. She looked at me. Ms. Calloway, you'll want to remain available. Of course, Your Honor, I said. I sat down. I straightened my exhibits. I took a slow sip of my water. Across the room I could hear Gerald Weston's low, urgent voice and my husband's responses, shorter and shorter, until they were almost nothing at all. The recess lasted 40 minutes, not 15. When we returned, Gerald Weston requested a continuance. Judge Okafor denied it. He requested to strike 3 of my exhibits on procedural grounds. She reviewed his objections for 4 minutes and denied those too. What followed over the next 2 hours was, in the language of law, a methodical dismantling. The documentation I had built over 2 years, every transfer, every LLC filing, every discrepancy between sworn depositions and actual account records, was entered into the record piece by piece. My husband's claims of separate property collapsed against evidence that those assets had been commingled with marital funds in ways that, under North Carolina law, made them subject to equitable distribution. By the time I made my closing statement, Gerald Weston had stopped objecting. I spoke for 9 minutes. I didn't raise my voice once. I had practiced those 9 minutes until the words came without trembling, because I had promised myself that when this moment came, I would be calm. Not because I wasn't angry, But because I had learned something in 14 months of preparing alone in the quiet of my apartment after long shifts, eating cereal for dinner and reading case law until my eyes burned, anger is fuel. Calm is a weapon. I thanked the court for its time. I sat down. Judge Okafor looked at the room for a moment, then she said, "I'll have a ruling within 14 days. Given the additional complexity this proceeding has surfaced, I'll also be issuing a referral to the U.S. Attorney's Office as a matter of judicial obligation." She looked at my husband over the top of her glasses. "I'd encourage you to seek comprehensive legal counsel before then." My husband said nothing. I walked out of that courthouse alone, the same way I had walked in. The ruling came in 11 days. Equitable distribution of all marital assets, including 4 properties that had been claimed as separate. A forensic accounting order. Retroactive support payments covering the 14 months of the separation. The federal investigation is ongoing. I'm not going to say more about that, because some things are not mine to tell. What I will tell you is this. The morning after the ruling, I went to work. I coordinated a Phase 3 cardiac trial enrollment meeting, answered 31 emails, and ate lunch at my desk. A sandwich I had actually had time to make that morning, for the first time in a long time. My colleague stopped by my office around 3 o'clock. She sat on the edge of my desk and said, "You seem different today." I thought about that. "I think I'm just tired," I said. She looked at me for a moment. "No," she said. "You seem lighter." I think she was right. There is something they don't tell you about standing up for yourself in a room full of people who have decided you can't. They expect you to be nervous. They expect the folder to shake in your hands. They expect you to apologize for being there. I had been nervous. My hands had been steadier than I expected, but my heart rate that morning had been something I would have flagged in a trial participant. But here's what I learned. The room doesn't know what's in your folder until you open it. And if you have spent every quiet, tired, overlooked hour of the last year building something true and careful and precise, they cannot take that from you. Not with 3 attorneys. Not with a dismissive smile. Not with a kitchen table and a pen and the words "you can't afford to fight it." You fight with what you have. Sometimes what you have is enough. Sometimes, if you've been paying attention, it's more than they ever saw coming.